Have you spoken to your attorney about the recommendations from the probation department?
Yes, I have.
Sit tight for just a little bit longer. We're just waiting for your attorney to appear, okay?
Okay.
Thank you.
Well,
Good morning, Mr. Nunley.
Morning, Judge. How are you?
I am wonderful. How are you?
I'm pretty good.
I already checked in with Mr. Flake. Do you need to speak to him before his case is called?
No, we spoke yesterday.
Okay. This is 220285 SM. This is State of Michigan versus Terrell Flake. May I have your appearances, please?
Royce Nunley appearing on behalf of the defendant.
Terrell Flake.
Thank you. Today is the day and time set for sentencing in this matter. Mr. Nunley, you've indicated that you've already spoken to your client and reviewed the recommendation from the probation department.
That is correct. We have no additions, deletions, or corrections to the report.
Thank you, sir. This is a case with a date of offense of April 14, 2022. Out of Van Buren Township, Mr. Flake was charged with 1 count of domestic violence. Entered a plea of guilty to that charge on June the 28th, 2022. The court sent the matter to the probation department to prepare a sentence recommendation. And Mr. Nunley, is there anything you'd like to say on behalf of your client before this court imposes sentence in this matter?
Yes, Your Honor. It seems like Mr. Flake is now on the right path. He indicated to me yesterday that he does now have a period of sobriety of I believe it was 2 or 3 months, which I think was maybe the root of some of these problems that we're addressing here today. He seems pretty serious and pretty happy about his recovery. I wish him the best going forward, but I think that if he can maintain his sobriety, I think that, he has a good chance of not being before this court. Again, he's remorseful for what happened. He's looking forward to putting it behind him, doing whatever it is the court imposes for a sentence and moving forward with his life in a more positive way.
Thank you, Mr. Nunley. I guess what gives this court cause for concern is that Mr. Flake had a case involving the same victim a year before this offense date, and he since has picked up a new case out of the 14A1 court. Mr. Flake, yes, sir.
That's my son's mom. So I mean, we get into it, well, we were getting into it, but I haven't had any contact. My son has his own phone now to where I don't have to worry about it. So I could talk to him directly. The cause of the trouble was me trying to contact her to get a hold of him half of the time. So now there has been no contact, no anything. Out of 14A, sorry.
I'm sorry, no, go ahead.
Yeah, out of 14A, they actually put me on the sober link and it changed my life, believe it or not. I've been sober for 2 months, feel a lot better every day. My family telling me how proud they are of me. So that means a lot.
Mr. Flake, I appreciate that, and I am glad that you see the benefit in the sober link. When I reviewed your file, my question that I wrote on my little cheat sheet here is, how old is the child in common? Because I saw that that was the source of the friction.
Yes.
But I appreciate the path that you're on.
Thank you.
And the court has had the opportunity to review the police report in this matter and the sentence recommendation made by Stephen Hicks, and this court will adopt that recommendation in its entirety. Mr. Flake, the court will put you on 12 months of probation. You will pay the oversight costs associated with that. Impose a fine of $500, cost of $200. There's mandatory crime victims of $75, mandatory state costs of $50, fund fee of $20. The court will assess 48 hours of community service. If you have a nonprofit organization that you volunteered with in the past, you can do that again. If you need one, contact the probation department. They'll give you a list of places where you can get those hours in. Those hours need to be completed during your 12-month probation. Court will impose a 26-week batterers counseling program to begin within 30 days of today's date. You will provide documentation of completing that program to the probation department. You are to have no contact with the victim in this case, that being Angela Baumeier, Bohmeier. You've already indicated to the court that now that your son has a phone, there's no reason for you all to have direct contact with each other. I know that might get dicey as we get towards the holidays, but you know, it is what it is.
Right.
You're already on sober link, but Mr. Hicks has asked that one of the conditions be that you not purchase, possess, consume alcoholic beverages or controlled substances without the court's approval. And I am adopting that. Random testing as directed by probation. Make payments on the fines, costs, and oversight fees that have been assessed in this matter. And Mr. Flake, I tell people that the job of the court is not to punish you and not to set you up to fail. Saying that to say that if there's anything that we can do, anything that the probation department can do to help you be successful over the next 12 months, do not hesitate to reach out to them and let them know what it is you need by way of support. If you're struggling to get your hours done for community service, say something early. If there's anything that we can do, let us know, okay?
Okay.
The probation department will be in touch with you, sir, over the next day or so to get you set up on your payment plan. Make sure that you sign all the forms associated with the sentence that the court has imposed. Anything else in this matter, Mr. Nunley?
No,
Anything else, Mr. Flake?
No.
Good luck to you, sir. Good luck in the 14A1, okay?
All right. Thank you.
Have a good day.
You too.
Thank you.
Judge, I don't know if anyone was made aware, but I'm filling in for Josh Hadley for your BOP docket today.
Thank you.
I don't know if you're gonna need me or whatever, but just so everybody's aware, he is on vacation. So if there's anything, then I'll be the one who stands in for him.
He told me last time I saw him that he was going to be on vacation. I suggested to him that he zoom in, but he did not. He didn't bite at that. Thank you,
Yeah.
Mr. Dudley.
No problem. I'll see you soon.
Good morning, Mr. Clark.
Good morning, Your Honor.
How are you, sir?
I'm all right.
Your case is not scheduled until 9:45. Did Mr.
9:45.
Daly ask you to join us early?
I believe I contacted the probation department and asked them what time, and then I believe she said 8:45. I could be wrong.
My docket says 9:45, but let me pull out your file and double check. It's 9:45, sir.
Okay, ma'am, I can come back.
Thank you. I'll see you later.
Thank you. Bye-bye.
Good morning, Mr. Lamar.
Good morning. How you doing, Your Honor?
I am wonderful. How have you been?
Hey, been blessed and well. Taking
The
care of
workout
business.
still going good with the kids?
Hey, everything's going awesome. Changing kids' lives, getting them out of here, getting them on their way. That's my job. That's what God got me to do. Definitely.
We're just
Definitely.
waiting for Mr. Hall to show up, okay?
All right, sounds wonderful. I don't know if I'm allowed to say anything or talk to you. Am I allowed to do that?
You will once Mr. Hall is here, okay?
Okay. Okay. Awesome.
Your Honor,
Shannon Rapp.
yes. I didn't know if you knew this, but your camera's now at the jury box.
I know, because
Oh.
I'm doing stuff and it's weird.
Okay, I just didn't know if you knew that or not, so I wanted to let you know.
I was sitting here by myself making notes, and it's weird to just have the camera on me when I'm by myself, but now Mr. Lamar's here and Mr. Hall will be here. But thank
So
you.
I just wanted to make sure.
I change it back and forth because I walk through here too, and I don't like the camera picking me up coming in this door
I
without
get
a
that.
robe on, so, but thank you. I'm just this disembodied voice to people who join the room too, and they don't know that it's me. They'll start saying, when the judge is ready, I'm like, the judge is ready. The judge has been here since 8, so.
All right.
And I need to find that file that you brought up so I can look at it, the 9:15. That name is ringing a bell.
It was
Which
just
is never-
adjourned 30 days.
I was gonna say, it's never good when somebody's name sounds familiar. Oh, okay, yeah.
Oops.
And we're arraignment, Shannon, so I'm waiting for Andy, see if anything's ready. Oh, of course something's ready. I told her that I'm by myself today, so we'll see what happens.
Get off of there. Sorry about that.
Mr. Lamar, mute yourself with me until Mr. Hall gets here, please.
Mute. Okay.
If you know, I'll do it. And when he gets here, I'll unmute you so you can talk. "29 pages. Shannon, I can't read 29 pages.
29 pages for what?
Andy,
Oh. I'm like, I don't remember sending you documentation for 29 pages.
well, I tell people I read everything, I read everything before I take the bench. That's why I read these files yesterday. But when Andy sends me something, I have to hurry up and read it for the stuff that I need. Which is just the warrant information, the probation not the probation, the bond recommendation. So I had a conversation on Saturday morning with some people about community service. Because they said, well, is there any mandate that you all judges do community service? I said, it's not a mandate, but I think it's nice when people see you out and about. And if you do stuff that you've been doing, people don't necessarily know how to say this, that you're a judge.
Right.
Like, there are people who I volunteer with that don't know that about me because it's not important to what we're doing. And I think that if people did community service, they would see That when we send people to do 12 or 36 or 48 hours, what it actually takes to get that in. Putting it around your work schedule and everything else.
Right.
And part of it is that there are 587 judges in the state of Michigan, just state judges. That's a lot of judges.
Yeah,
But I had my nice little graphs and charts and everything else. 587, that's a lot. Holy smokes. Uh-oh. Is everybody except Mr. Hall? I think I'll call him in just a minute. It's only 8:45. It's still early. Andy, I received your email and I'm reviewing it right now.
Sounds good, Judge. Thank you.
You're welcome. Good morning, Mr. Hall.
Good morning, Your Honor.
This is 194696 SM. This is State of Michigan versus Jason James Lamar. May I have your appearances, please?
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Lamar. We appear via Zoom this morning without any objection to appearing in that manner today. Mr. Lamar, could you unmute and say your name for the record, please?
Good morning, Your Honor. My name is Jason Lamar.
Thank
Thank
you.
you.
Today is the day and time set for the sentencing in this matter. This case had an offense date of November 12, 2019 to count one, domestic violence with a second offense notice, count two, assault and battery of a pregnant individual. This court conducted a jury trial in this matter on July 15, 2022. Jurors found Mr. Lamar guilty of both of the charges against him. The court sent the file to probation to schedule a sentencing and give notice to the victim in this case, Miss Emily Smith, to see if she wishes to submit a victim impact statement or make some other comment as to the sentence in this matter. Case was scheduled at 8:45 this morning. This court has not received any response from Ms. Smith at this time. She has not appeared yet this morning. Mr. Hall, is there anything you'd like to say before this court imposes the sentence on Mr. Lamar?
Your Honor, as Your Honor knows, one thing I think important in cases like this, during dependency of this matter, there were no violations on behalf of Mr. Lamar regarding any form of no contact or attempt to threaten or interfere with Ms. Smith. Your Honor, Mr. Lamar spends his professional life working with children, helping young kids learn the game of football, helping them learn competitiveness, teamwork, and the like. He has been a great influence on an incredible number of young men as he pursues his profession. Judge, Mr. Lamar is going to respect all the orders of this court. He's going to move forward with his obligations as dictated by Your Honor. And as he appears here today, Your Honor, he's ready to move on with life. He is certainly, he certainly understands the constructs that bring him before Your Honor and the complications involved. And he is going to move forward in a way that proves to Your Honor that Mr. Lamar is a man who respects the courts and knows how to comport his behavior in regard with the law and in regard with Your Honor's expectations. And for those reasons, Judge, we would ask that you allow Mr. Lamar to continue to pursue his given profession and show the world that he is a contributing person who is able to help others and not detract from society.
Thank you. Mr. Hall, before you joined us, Mr. Lamar asked me if he could say something to me. And I told him no, to wait for you to appear. I don't know if that was a conversation that you had with him about what it was that he might say this morning. But I wanted to say that I told Mr. Lamar that he would have the opportunity to speak. So that being the case.
Thank you,
Mr.
Judge. And yes, Mr. Lamar, yes, you may address the court if you like.
Yes. Thank you. Your Honor, what I wanted to say, my experiences in life, you know, my upbringing and the things that I've endured and to become a upstanding citizen and hardworking man in society and life, you know, regardless of what happened in the courtroom and me being found guilty by the jury, I have morals and values. I have a 14-year-old daughter that I love dearly, and I take care of. And, you know, regardless of, like I said, the situation that's happened, it will forever now, like I said, beginning me moving forward in my life has impacted my life. Definitely, the situation, it is taking me away from my child. Like, I'm not able to see her. I can't see her. I can't go visit her in Canada. You know, but like I say, I respect decisions and things are made. But again, I just want to let you know, I have morals. I don't believe in touching women. I don't believe in hitting women. Like I said, I have a daughter of my own. I love her to death. And my mom, I love my mom to death. I lost my father in 2010, but I'm just not that kind of person. I don't operate like that. I don't believe in that. You know, like I say, regardless of whatever happened, I'm an upstanding citizen, Your Honor, and I love to help people. I want to help people, and I want to see everybody successful. I'm not that kind of person. I don't get into trouble. I stay out of trouble. Like I said, I just take care of business. And I just want you to know that that's my character. I'm a graduate of the University of Toledo, and I got my BA in criminal justice. I take care of business. I'm not a person out here causing harm to anyone. And like I say again, Your Honor, I don't believe in putting my hands on females. Thank you.
Thank you. Mr. Lamar, do you have any reason to have contact with Ms. Smith?
Not at all.
Okay. Mr. Hall, we took a break during the jury trial and the court officers went to look for you. Mr. Lamar and I had a brief conversation just about the day before, nothing to do with the case. He yawned. He was sitting in the courtroom and he yawned, and I asked him about it. And he told me about the young people that he was working with, and his face lit up in a way that it had not during any of the proceedings leading up to that moment. And after that moment, he was a completely different man in that space. Saying that to say that this court takes him at his word that he is a man of morals and standards, and the events of November 12, 2019 were out of character for him at best. And I'll leave that at that. The court did not send Mr. Lamar to probation for a sentence recommendation, but just to allow Ms. Smith the opportunity to appear and speak when she was not. I think witnesses speak differently and say different things when they're under oath and have an attorney standing so close to them. I wanted her to have the ability to speak without being interrupted, without feeling like she was being badgered. Mr. Lamar, the court does not believe that you would benefit from any jail time in this matter or any additional programming. Inasmuch as you have no reason to have any contact with Ms. Smith, the court will impose no contact. The court will put you on 6 months of non-reporting probation because the court wants you to do 24 hours of community service and provide documentation of that to the probation department. The court will also impose the following fines and costs. For the count 1 domestic violence count, it will be $500 fine, $300 in costs, $75 crime victim fee, $50 mandatory state costs, $20 fund fee, $70 reimbursement, and $20 fee for a total of $1,035. For count 2, there'll be a fine of $100, cost of $100, state costs of $50, and fund fee of $20. That's $270. The total fines and costs will be $1,305. The court will apply your existing bond to those fines and costs, and you will need to be in communication with the court's collection department to set up the balance of the payments in this matter.
Yes, Your
Anything
Honor.
else, Mr. Hall?
Nothing further, Your Honor. Thank you so much for having us today.
Anything else, Mr. Lamar?
No, thank you so much, Your Honor. I appreciate you.
You're so welcome, sir. You have a wonderful day, okay?
You too.
Take care,
Thank you.
everybody.
Good morning, Mr. Matthews.
Good morning, Ms. Martin.
How are you, sir?
All right, how you doing?
I'm good. Your connection seems a little unstable. Have you been in contact with Mr. Davis regarding, oh, maybe not. No, nobody's been invited to join the breakout rooms.
Is that better?
Mr. Matthews,
Yes, ma'am.
it does sound better. I have not seen Mr. Davis yet this morning. Have you been in touch with him regarding today's hearing?
The lawyer that was present at my trial, I spoke to him this morning. He said he would be
Okay.
present.
Good morning, sir. Thank you. Andy, what time did you tell something?
So I have sent the information to our MIDC for today, Crystal Medina, and asked her to contact the PD. So I have not set a time for this one.
Okay, thank you, ma'am.
Mhm.
Good morning, ma'am.
Good morning.
Is Mr. Gosinski with you? Or are you expecting him? Oh, he joined separately. I see him right now.
Yeah, he was joining separately.
Have you already had the opportunity to speak to him about the recommendation from the probation department?
Yes, I have.
Okay. This is 22HR 030910D. This is Huron Township versus George Michael Gosinski. May I have your appearances, please?
Good morning, Your Honor. Jacqueline Tice appearing on behalf of George Kuczynski.
State your name for me, please, sir.
My name is George M. Gozinski.
Thank you. Today is the day and time set for sentencing in this matter. There was an offense date of April the 7th, 2022 in Huron Township, at which time, sir, you were charged with operating while intoxicated. You appeared before this court and entered a plea of guilty to the reduced charge of operating while visibly impaired on July 14, 2022. In keeping with the policy of this court, you were sent to the probation department for a screening and the development of a sentence recommendation. Ma'am, you've indicated that you've had the opportunity to review that recommendation with Mr. Goskinski,
Yes, I have, Your Honor.
and you're ready to proceed with sentencing this morning.
We are.
Ma'am, was the report factually accurate?
It is factually accurate.
Do you believe that any additions, corrections, or deletions are needed?
I would just indicate to the court that, Mr. Kaczynski has taken this matter very seriously, probably more seriously than many of the clients I've had over the years. And I'm personally familiar with George Kaczynski. I've known him for years. I think I attended his wedding. I also, one of my secretaries is his ex-mother-in-law, and the family has remained close. So I've known Mr. Kaczynski for years. And I can tell you personally that this has really affected him, and he's learned from this experience, and he has taken to heart the recommendations that have been made. He is seeking counseling. He is not drinking or using any substance at this point. And we say it all the time. Attorneys say you will never see him again, but I really feel sincerely in this case, because of my experience with Mr. Kaczynski, that you will not see him again. And that I think he is using this as a growth experience and gaining in insight.
Is there anything he'd like to say before sentence is imposed?
I really don't have anything to add, Your Honor. Just embarrassed, scared, and humiliated, I guess. I'm afraid it ever happened.
This court's only concern, this court's only concern is that Judge Oakley arraigned Mr. Goscinski on May 26, 2022, and put in place a no alcohol condition of his bond. Yet Mr. Goscinski continued to drink for 2 months after that, drinking as recently as a day or two before his interview with Stephen Hicks of the probation department. And I understand that some habits are hard to break, but if I were under threat of jail,
Okay,
fines, costs, treatment order, and everything else, I think I would be scared, but that's
okay,
Mr. Goscinski, that's an aside more than anything else, because this court has 10 sentencings this morning, and you are one of the least intoxicated people on the scheduling. So
okay.
0.15.
All right, I do want to add this as far as that. When Judge Oakley had ordered the no mind altering drugs, I looked at whether it was like acid, LSD, mushrooms, and all that being as mind altering drugs. As far as that, I did not consider that alcohol was it, although afterthought now things like, well, that's what got me busted, duh. So yeah. So I didn't think the habitual a glass of wine with dinner or a pizza with beer with buds would be a problem. But seeing that was Mr. Hicks had spelled out, no, you're not supposed to do that, I was like, done. So.
And he
I
hasn't
appreciate
had
the
anything.
explanation. I'm sorry, ma'am,
Yeah.
go ahead.
And he hasn't had anything, and I can tell you that's where I see a difference with him than other clients. He really takes it, he analyzes things and he looks at it and he said, yeah, that's a problem.
I appreciate that explanation, and in looking at your age and the fact that this is your first offense, first drinking and driving offense, means that this wasn't one-off for you. This is not something, like as your attorney indicated, that this court will see you again. This court will adopt the recommendation made by the probation department and will place Mr. Goscinski on 12 months of probation with all associated oversight fees. Will impose a fine of $300, cost of $100, crime victims fee of $75, $50 mandatory state cost, $20 fund fee, $241 of reimbursement to Huron Township. Will place him on 30 days of alcohol monitoring. The recommendation was 30 to 60, but we'll place him on 30 days of alcohol monitoring at his own expense. He will engage in substance abuse treatment beginning within 30 days of today's date and follow all recommendations and requests for documentation made by the probation department. He is not to purchase, possess, consume any alcoholic beverages or controlled substances without this court's approval, and will submit to random testing as directed by the probation department. He will make payment as to all these fines and costs during the term of probation. Mr. Kaczynski, if you are able to complete all of the terms of your probation, except for the fines and costs part, you may be eligible for early discharge once you have completed half of your probation period. Saying that so that you are mindful that if you get things done early, the earlier the better.
Thank
Understood,
you.
understood.
Okay. Anything else on behalf of Mr. Kaczynski, ma'am?
No, Your Honor.
Ms. Kaczynski, the probation department will be in contact with you in the next couple of days to set up the paperwork necessary for you to be on probation to this court, okay?
Okay, one question as far as the substance abuse program, would that also be set up by the probation officer?
Mr. Kaczynski, I think you said you had a place that you were going to contact.
Oh.
You should contact them.
Okay,
And they
okay.
can make the report then, right?
okay, will do.
If you needed direction for that purpose, probation department is there, but if you already have some place in mind, you'll just need to provide documentation to probation.
Right.
Just want to know, no action. Okay.
Thank you, Your Honor.
Thank you, ma'am. Have a good day.
You too. Bye-bye.
Good luck to you, sir.
Thank you, Your Honor.
Good morning, Mr. Clayton.
Good morning, Your Honor.
Do you need to speak to Mr. Matthews?
No, we're ready to go. I spoke with him this morning.
Give me one moment to make some notes, please.
Well. No, no.
This is 220160SM. This is State of Michigan versus Robert Matthews. May I have your appearances, please?
Good morning, Your Honor. Spencer Clayton appearing on behalf of Robert Matthews, P number 77302. Mr. Matthews, can you state your name for the record, please?
Robert Matthews.
Thank you. Today is the day and time set for the sentencing in this matter. Mr. Clayton, you've already indicated that you've reviewed the recommendation made by the probation department with Mr. Matthews and you're ready to proceed.
That's correct, Your Honor.
And sir, did you find the report to be factually accurate?
I did, Your Honor.
Any additions, corrections, or deletions necessary?
No, Your Honor.
Anything you'd like to say on behalf of your client before sentence is imposed, sir?
Your Honor, I think the recommendation is appropriate, given my client's background as well as the charge. I would indicate to the court, he does work 6 days a week at night, works night shifts. So the only thing I'd ask the court to consider is possibly an anger management class instead of the batter's program. And that's so he could do that at a time that's more appropriate, but obviously we would respect whatever the court wants to impose as a sentence. Thank you.
Thank you, Mr. Clayton. This was a case with one count of domestic violence. The offense date was November 14, 2021, out of Van Buren Township. There was a bench trial conducted in this matter on July 18, 2022, at which time this court found Mr. Matthews to be guilty as charged. The court sent the file to the probation department to allow them to craft a sentence recommendation and to send notice to the victim in this case, Ms. Amber Long, to see if she wished to submit a victim impact letter or appear this morning and make any comment as to the sentence that might be imposed on Mr. Matthews. The sentencing this morning was scheduled for 9 a.m. It's now 9:15 a.m. by the court's clock. Ms. Long has not appeared this morning. Ms. Rapp, would the probation department have any comment as to the request by Mr. Clayton that the recommendation at number 5 be amended from the 26 weeks of batterers counseling to anger management?
Probation would have no discrepancy.
Based on that comment, Mr. Clayton, the court will adopt the recommendation of the probation department and assess and place Mr. Matthews on 12 months of probation with all oversight fees associated with that. Will impose a fine of $500, cost of $300. There's $75 crime victims fee, $50 mandatory state cost, $20 fund fee. There is a $50 show cause fee from a prior failure to appear, a $50 warrant fee. The court will amend the recommendation as relates to number 5 and will not place him on, not assess 26 weeks of batterers counseling, but send him to anger management, send Mr. Matthews to anger management. Mr. Matthews shall not purchase, possess, consume any alcoholic beverages or controlled substances without the approval of the court, and will submit to random testing as directed by probation. Because Mr. Matthews and Ms. Long have a child in common, the court will leave a requirement that they have no assaultive contact. Mr. Matthews is to make payment of the fines and costs assessed in this matter over equal payments over the next 12 months. Anything else on behalf of your client, Mr. Clayton?
No, Your Honor. Thank you.
Anything else, Mr. Matthews?
No, ma'am.
Thank you. Mr. Matthews, the court wants you to be successful in probation. If there's anything that you need, any support you need from the probation department, reach out to them when you're having a little bit of a problem. Don't let it become a big problem, okay?
Yes, ma'am.
Thank you so much. Have a good day and good luck to you, sir.
You too. Thank you.
Thank you. Good morning, Mr. Lynch.
Good morning.
How are you, sir?
I'm good. How are you this morning, Your Honor?
I am wonderful. Let's see what's going on here. Mr. Lynch, you're scheduled at 9:30. You're just a little bit early. I have not seen your attorney yet this morning. If you want to stay put, you may do so.
Okay, Your Honor.
Thank you.
You're welcome.
Mr. Siciliano? Mr. Siciliano?
Yes,
How are you this morning, sir?
good.
Have you had the opportunity to review the recommendation with your client
I have,
and you're ready to proceed this morning?
we are. And I
This is
have a 9:30 on another court, so if we're ready to go, that would be ideal.
I was trying to call the case just now. This is.
Okay, that's what I could
22
sense. That would be great.
22SU004640D. This is Sumter Township versus John Scott Lynch Jr. May I have your appearance, please?
Good morning, Your Honor. Joseph A. Siciliano, appearing on behalf of the defendant, Jonathan Scott Lynch.
Mr. Lynch, state your name for the record, sir.
John Scott Lynch Jr.
Thank you. Today is the day and time set for the sentencing in this matter. There was an offense date of April the 26th, 2022, out of Huron Township. Out of Sumter Township. Mr. Lynch was charged with operating with blood alcohol content of 0.17 or more. He appeared before this court on July 14, 2022, and entered a plea to the reduced count of operating while visibly impaired. As is the court's policy, Mr. Lynch was referred to the probation department for interview, sentence recommendation, schedule of sentencing. Mr. Siciliano, you've indicated that you reviewed the report with your client. Is it factually accurate?
It is factually accurate, although we do have some comments to make at the appropriate time.
Any additions, corrections, or deletions?
Factually, no.
And what is it you'd like to say on behalf of your client before a sentence is imposed in this matter, sir?
Your Honor, the assessment indicates that this is a third alcohol-related offense since 2012. That is true, but it should be noted that the first two were minors in possession, and they occurred 9 to 10 years ago when Mr. Lynch was 17 or 18 years old. Up until now, he's had no problem. His record has been clear. He has a very good job as a crane operator, which requires him to work many, many hours. He realizes he made a mistake in this instance, and he apologizes to the court for his actions. But this offense has already impacted his job, as he has a CDL license, and his CDL license has been suspended. Because he's such a good worker, his employer is willing to work with him as he gets through this, even with the limited capacity that he has. He believes this is an isolated instance, and he vows that this will never happen again. And we just request that because that the sentencing be commensurate with an isolated instance, so it doesn't impact his job any further than it already has.
Saying that to say what, sir? What are you looking for different than what's in the recommendation?
Well, we don't believe there should be reporting any probation or reporting probation for sure. And not that, I understand 6 months is 6 months, but it shouldn't be reporting. And he doesn't mind doing the community service. He realizes he made a mistake. And again, maybe he was given the impression that there wasn't going to be any probation, because at least his understanding with the discussions is that they said, yes, they recognized appears to be an isolated instance. He made a mistake. He's not wishing to, he's embarrassed by it. And he knows but he's suffered a lot already through his job. And so therefore I request, we would request that it wouldn't be, or be probation limited, or no probation, or very limited time, and certainly non-reporting.
Ms. Rapp, was there something you wanted to say?
Due to the fact that this is an operating while intoxicated, Hold on, let me pull it up. I apologize.
No worries.
I believe there should be supervision and the defendant should report monthly through Zoom.
Thank you. I heard your comments made on behalf of your client. I appreciate that. And in reviewing the report, I did note the age of the prior offenses and what they were. There is concern that Mr. Lynch had a .18. He was speeding. There was no accident. There was no one else involved, but that is, well, he's not the drunkest on today's sentencing docket, but he's getting close. That being the case, the court will adopt in part the recommendation made by Agent Stephen Hicks and will place Mr. Lynch on 6 months of reporting probation with all oversight costs associated with that. Will assess a fine of $300, cost of $100, $75 crime victims fee, $50 mandatory state cost, $20 fund fee, reimbursement of $125 to Sumter Township. Will not send him to alcohol education, but will impose a restriction that he not purchase, possess, consume any alcoholic beverages or controlled substances without the court's approval, and that he will submit to random testing as directed by probation. He will make payments as to the fines, costs, and oversight fees during this 6 months of probation. I skipped over, it looks like I did not say 24 hours of community service to be completed at a nonprofit with documentation to be submitted to probation as directed. And because you have some concerns about how reporting probation might impact him, I will advise that Mr. Lynch may be eligible for early discharge from probation, provided that all the terms have been met and he has completed at least half the probationary period, encouraging him to get the requirements of the court done sooner rather than later. Anything else on behalf of your client, sir?
No, Your Honor.
Anything else, Mr. Lynch?
No, Your Honor. I just would like to get everything done as soon as possible and put this behind me and take it as a hard life learning lesson.
Thank you. Probation department will be in contact with you in the next couple of days, sir, to get you set up on probation, okay?
Okay, thank you, Your Honor.
Have a good day. Good luck to you.
Thank you, Ms. Rapp.
Thank you.
Thank you. Bye.
Very prompt, Mr. Clark. Thank you.
No problem.
Mr. Harris?
Sorry, it's Laura.
Good morning, Ms. Pierce. Thank you.
Sorry, I'm signing underneath my husband's.
No, it's okay. Let me fix it. Have you spoken to your attorney regarding this morning's hearing?
No, so I'd spoken with the prosecutor, and we had come to an agreement. I talked to and did a meeting with the probation
Oh.
officer.
Ms. Pierce?
Yep.
I'm sorry. It's okay. There was a note in the file. That's the officer's name. You waived the right to have the assistance of the attorney.
Yep.
Okay.
And I know I'm early. I just wanted to make sure I could log in. I was like, all right, let me make sure.
You're fine. Ms. Pierce, did you receive the recommendation made by the probation department?
Yes, ma'am.
And you were ready to proceed this morning?
Yes, ma'am.
And ma'am, you wanted to proceed on your own?
Yes, ma'am.
Ma'am, this is 22 HR 04116 AOD. This is Huron Township versus Laura Pierce. State your name for me, please, ma'am.
Laura Pierce.
Thank you, ma'am. Today is the day and time set for sentencing in this matter. There was an offense date of April 9, 2022 out of Huron Township, at which time you were charged with operating with a blood alcohol content of 0.17 or more. You appeared before this court on July 14, 2022 and entered a plea of guilty to the reduced charge of operating while visibly impaired. The court, as is this court's policy, sent you to the probation department for interview, the preparation of a sentence recommendation, the scheduling of the sentencing. The court has had the opportunity to review the report from the probation department as prepared by Stephen Hicks, along with the police report in this matter. Sir, ma'am, you also had the opportunity to review that information?
Yes, ma'am.
And was there any comment you wanted to make about either the report that was generated or the sentence recommendation that was made?
No, ma'am.
And ma'am, is there anything that you'd like to say before sentence in this is imposed in this matter?
No, ma'am.
Okay. Ms. Pierce, the court in reviewing the recommendation notes that Stephen Hicks indicates that due to you denying the need for treatment and stating that this offense is an isolated incident, that the probation department not recommend that you be placed on probation. Mr. Hicks also did not indicate any need for treatment in this matter. The court in reviewing the police report in its entirety has some concerns that you were out and about with a blood alcohol content of 0.283, would suggest both to this court and the probation department that you ingested a lot more alcohol than you indicated to Mr. Hicks during that interview. You indicated to him 8 drinks, but based on your blood alcohol content or height and weight, it suggested this court more in the order of 12 to 14, which causes this court concern. But if it's your position and your statement to the probation department that this is a one-off, that this is not your usual habit, your usual way of living and moving through life, the court has to take you at your word and will adopt the recommendation made by Stephen Hicks and will not place you on probation, but will assess a fine in the amount of $300, cost in the amount of $300, $75 mandatory crime victims fee, $241 of restitution to Huron Township. There is a $50 show cause fee for failure to appear, a $50 mandatory state cost, and $20 fund fee. That's a total of $1,036. The court will also assess 48 hours of community service to be served at a nonprofit with documentation provided to the probation department. If you do not have a relationship with a nonprofit organization, that you can do this community service, these 48 hours of community service hours, contact the probation department and they will assist you in getting connected with an organization. The court will allow you 6 months to complete this community service hours. Ma'am, I don't see that you posted any bond in this matter, so you'll need to contact the court's collection department to set up a payment plan of the fines and costs assessed in this matter.
Okay.
Anything else, ma'am?
No, ma'am, I'm just writing it all down. Okay, nope, I'm good. So it's 1036 in court costs, 48 hours of community service that I have 6 months to complete, and to contact the collection department at the courthouse to set up a payment plan.
Yes, ma'am. Or you can go online to the court's website. There's a contact us button that you can hit and drop down to submit a request for a payment plan.
Okay,
Okay?
okay,
Thank you, Ms. Pierce. Good luck to you. Have a good day.
thank you. You as well.
Thank you. Good morning, Mr. Miles.
Good morning, Your Honor.
How are you, sir?
I'm all right. Currently at work right now.
Mr. Miles, this is 1909000OD. This is City of Romulus versus Miles. You were here about 30 days ago. We are looking for documentation regarding your community service. You've now submitted documentation showing that you actually went over the necessary community service hours, and you have continued to make payments in this matter. There's a balance of $525 due and owing. There's no new offenses on your driving record or your criminal history. What we'll do, sir, is find that you have complied with this court's order as to date. Ms. Rapp, was there anything else you wanted to add?
No, Your Honor.
Mr. Miles, we will not adjourn this matter further. What we will do is just indicate that you are to continue to make your payments as previously directed by this court and go back to work. Okay, sir?
Okay, thank you, Your Honor. Have a great day.
Have you too. Thank you, sir.
You're welcome.
Poor Mr. Grant has to sit through my musings.
Judge. Yeah, so we can say. Who's about to get water? Maybe leave that with this guy. Yeah, he'll just.
Good morning.
Good morning.
This is 220589 FY. This is State of Michigan versus Alan Rains. May I have your appearance, please?
Yes, Your Honor. Crystal Marie Medina on behalf of Mr. Rains. With regard to the arraignment, we would waive formal reading and stand mute, Your Honor. Mr. Rains, would you please state your full name for the record?
Alan Rains.
And Mr. Rains, you were able to speak to Ms. Medina this morning regarding today's arraignment.
Yes.
Thank you, sir. Mr. Rains, you have an absolute right to be represented by an attorney in this matter. If you are unable to afford an attorney through your own resources or through that of family and friends, the court has the ability to appoint an attorney to you going forward. There was a petition for a court-appointed attorney attached to the front of your file. The court has signed that. You'll be assigned an attorney going forward. It will not be Ms. Medina. So the attorney assigned to you will rely on the phone number and email address that you provided to be in contact with you regarding this matter going forward. Sir, you also have the right to be considered for pretrial release. The recommendation from the police department is that your bond be set at 5,000, 10%, that you have no contact with any of the victims in this case, that you do not engage in any alcohol or drug use during the pendency of this matter. Ms. Medina, what say you as to this bond recommendation?
Your Honor, I would just like to note for the court, I'm not sure if Mr. Rains is in a position to post a $500 bond at this time. He indicated that he would have to contact a family as he is expecting his paycheck. I believe it is later this week, Your Honor. My understanding is that Mr. Rains is 27 years old and his only criminal history is one misdemeanor conviction. He is employed full-time, Your Honor, at Livonia Towing and McLaughlin Drywall. He understands he's to have no contact with the complainants in the judge, and will be staying with his mother and father in Belleville. I would like the court to note that he currently does have a broken hand, Your Honor, and he does have animals at home that he is responsible to care for, Judge. And so I would just ask that the court consider, I'm not sure if the court would be willing to consider giving him the opportunity to be released on a personal bond. I just am not sure as to his ability to post that $500 bond at this time, Your Honor, his access to that money.
Thank you, Ms. Medina. The court will adopt the recommendation of the police department and set his bond at 5,000, 10%. He's to have no contact with the victims in this case, no alcohol or drug use. The court is not placing Mr. Rain on personal bond because of the indication from the police department that in addition to allegedly damaging a police patrol vehicle, he assaulted two random people and was involved in a domestic incident in the span of a short period of time on August 13, 2022. Mr. Rain will have the opportunity to reach out to family and friends to post that $500 on his behalf. Ma'am, the next date in this file will be the probable cause conference, which will be on Wednesday, August the 24th, 2022, in courtroom number 1, back with me, Judge Martin. Again, this file number is 220589 FY. Next appearance date is the PCC on August 24, 2022 at 8:30 a.m., courtroom number 1. Anything else, Ms. Medina?
No, Your Honor. Thank you very much for your time.
Anything else, Huron?
No, Your Honor. Thank you very much.
Thank you so much. Have a good day.
You too.
Thank you.
Yeah.
Judge, for the PTR for Rains, is an email or okay, or did you prefer a paper copy?
Email will be fine. I think I can sign it from here.
Okay. I will
Thank you,
send
ma'am.
it over. Thank you.
Hmm.
Just to confirm, Judge, bond was set at 5,000, 10%, no drugs or alcohol, no contact of any kind with victims, correct?
Yes, ma'am.
Thank you.
Good morning, sir.
Good morning.
How are you?
I'm well. How are you?
I'm well. Have you had the opportunity to review the recommendation with
I have.
Mr. Clark?
We have.
And you're ready to proceed?
Yes, Your Honor.
These are 220443 FT and 22RP02283 BSI. These are both state of Michigan versus Jordan Lee Clark. May I have your appearances, please?
Jordan Clark.
Good morning, Your Honor. Attorney Luke Garinger, P85677, appearing on behalf of defendant Jordan Clark.
Thank you. Today is the day and time set for sentencing in these matters. The date of offense in both cases are June 13, 2022. Out of the city of Romulus, there was a civil infraction of no proof of insurance. The original charge in this case was fleeing police officer, 4th degree. Mr. Clark appeared before this court on July 20th, 2022, and entered a plea of guilty to attempt flee. The court sent the matter to the probation department for an interview and sentence recommendation, as the court has some concerns about Mr. Clark's behavior on the day of offense. Mr. Garinger, you've indicated that you've had the opportunity to review the recommendation with your client. Sir, was the report factually accurate?
Yes, we have no additions or corrections or deletions at this time, only elocution.
Anything you'd like to, thank you. Allocution, sir?
Yes, Your Honor. I've spoken with Mr. Clark about this, and he has expressed remorse. I know that he made a mistake here, and he has accepted responsibility for his actions. He has appeared for every court appearance. He's abided by all pretrial orders and bond conditions. And he is he's fully employed right now. He's working as a heavy machine operator for a construction company, and he is also engaged, and he has a support system through his fiance. And like I said, he just expresses remorse, I know, for this mistake, and wants to and is ready and willing to abide by whatever this court deems necessary. I would make one comment as to the recommendations. If I may, I believe there was a recommendation for outpatient drug or alcohol treatment contained in the probation department report. I would note that this was not a drug or alcohol related offense. And as such, we would request that the court waive such condition.
Anything else, Mr. Garinger?
Nothing further, Your Honor.
Thank you. The court, in reviewing the police report and the recommendation, reached the same conclusion as you, Mr. Garinger, did not believe Mr. Clark would appropriately be assigned to outpatient treatment. One of the reasons why the court had some concerns is that in reviewing the police report, there are indications that he reached speeds of up to 100 miles an hour. And additionally, he was driving 50 miles an hour on Wayne Road, which the speed limit is not that by any stretch of the imagination, that he got into some kind of kerfuffle with Corporal Kozowski. The court's concern was what would cause someone to engage in such behavior. I understand that there were some other outstanding issues, but speeds of 100 miles an hour on the freeway just suggests that there might be something else afoot. In any case, the court again has reviewed the recommendation in the police report and will impose the following sentence. Mr. Clark will be assessed $220 on the no proof of insurance. He will be placed on 12 months of reporting probation for the attempt fleeing. He will pay all oversight costs associated with that probation. He will be assessed a fine of $500, cost of $200, crime victims fee, $75, state cost, mandatory state cost of $50, and fund fee of $20. There's $125 of restitution to Romulus. 48 hours of community service at a nonprofit with documentation as directed by the probation department. Mr. Clark, you have the 12 months of probation to complete that community service. If there's not a nonprofit organization that you're already affiliated with, the probation department can give you a list of places where you can get your hours in.
Okay.
Again, because there's no indication of drug or alcohol use in the police report, the court will not impose the recommendations that appear at paragraph 7 regarding outpatient treatment, or paragraph 8, the purchase, possession of, or consumption of alcoholic beverages. Mr. Clark, you will resolve all active warrants. It says within 14 days with documentation to probation, but as much as some courts still have reduced hours or limited availability to schedule appointments, the court will allow 28 days for you to do
Thank you, Your
that, resolve the active warrants. If we get to be towards the 28 days and you still have not been able to do that, please reach out to the probation department so that there is a clear understanding as to the delay in the request for more time.
Okay.
You will make payments of all the fines and costs in both of these matters equally in a payment plan. Probation department will be in contact with you in the next few days, sir, to formalize your being assigned to probation, to complete all necessary forms associated with that probation, okay?
Okay.
Anything else, Mr. Garinger?
Nothing further, Your Honor. Thank you.
Thank you. Mr. Clark, before you leave, please understand that the court wants you to be successful while you're on probation. If you're having trouble getting any part of your probation done, do not hesitate to reach out to the probation department and ask for assistance. And as much as you've been placed on probation, sir, you are eligible for early discharge from probation, provided that all the terms of the probation have been met and you have completed at least half of your probationary period, okay?
Okay, ma'am.
Good luck to you, Mr. Clark. Have a good day, sir. Thank you for being so prompt today.
Thank you, Your Honor. Have a wonderful day too.
Thank you, Your Honor.
You too. Take care, Mr. Garinger. I knew as soon as I left Shannon that he would log on. And Mr. Nunley's back, so as soon as Mr. Q appears.
I also have Mr. Lopez, who I think is signing on early.
Okay. Mr. Nunley, did you need to speak to Mr. Lopez?
No, Your Honor.
He's here. Give me one moment. I'm stepping off for just a second, but I'll be right back.
Okay.
All right.
Yes, I will be right with you, Mr. Lopez.
Okay.
This is 22SU 00376 AOD. This is Sumter Township versus William Q. May I have your appearances, please?
Royce Nunley appearing on behalf of the defendant. I have
State your
not
name
had
for
an
me, please, sir.
opportunity.
Oh, sorry.
I haven't had an opportunity to speak with Mr. Q. I left him a message yesterday, but haven't heard back. So if I could have a breakout room with him very briefly,
Well, let's pass the matter. And if you said you've already spoken to Mr. Lopez,
that is correct.
so I'll call Mr. Lopez's case and then we'll move you in with Mr. Q.
Okay.
This is 22SU 00322 AOD, Sumter Township versus Antonio Lopez.
Royce Nunley appearing on behalf of the defendant.
State your name, please, Mr. Lopez.
Antonio Lopez, Your Honor.
Thank you. Today is the day and time set for the sentencing in this matter. There was an offense date of March 28, 2022 in Sumter Township, at which time Mr. Lopez was charged with operating a vehicle while intoxicated with occupants less than 16 years old, child endangerment. He appeared before this court on July 14, 2022 and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, the matter was referred to probation to interview Mr. Q, make a sentence recommendation, and schedule the matter for sentencing. The court has had the opportunity to review that recommendation as well as the accompanying police report. Mr. Nunley has already indicated that he has reviewed this matter with Mr. Lopez. Mr. Nunley, was that report factually accurate?
Yes, Your Honor. We have no additions, deletions, or corrections.
Anything you'd like to say on behalf of Mr. Lopez before sentence is imposed, sir?
Yes, Your Honor. I did have an opportunity to go over this report with him. He understands the seriousness of the charges with which he was charged. He is remorseful. He made it was a lapse of judgment. It was a mistake. He understands it was a mistake. He's looking forward to complying with all terms imposed by this court for probation and moving forward with his life in a positive manner.
Thank you. Mr. Lopez, is there anything you'd like to say?
No, Your Honor.
Thank you. Again, the court has reviewed the recommendation, the police report, and will adopt Mr. Hicks' recommendation in its entirety. We'll place Mr. Lopez on 12 months of reporting probation. We'll assess with all oversight fees associated with that probation, Mr. Lopez. Will assess a fine of $300, cost of $100, their $75 crime victims fee, $50 mandatory state cost, $20 fund fee, $125 of restitution to Sumter Township. There was a recommendation for 60 to 90 days of alcohol monitoring at your expense, Mr. Lopez. The court will assess the low end of that, the 60 days of monitoring. You will engage in parenting classes and follow all recommendations from those classes with documentation to the probation department as directed. You will engage in outpatient treatment beginning within 30 days of today's date. Follow all recommendations from that treatment program, as well as provide documentation to probation as directed. You will not purchase, possess, consume any alcoholic beverages during the pendency of your probation without court approval, and you will submit to random testing as directed by probation. Sir, because you've been placed on a term of probation, you may be eligible for early discharge of that probation, provided that all the terms have been met and you have completed at least half of your probationary period. Sir, you are also to resume the payments that you have on the other outstanding matters to this court. The court may make a singular payment plan to cover all of your outstanding matters. Anything else, Mr. Nunley?
Nothing further, Judge.
Anything else, Mr. Lopez?
No, Your Honor. Thank you.
Mr. Lopez, just so we're clear, the court's position is that they want you to be successful on probation. If there's anything that you need from the probation department to assist you in completing the sentence that's just been imposed, please do not hesitate to reach out to them, okay?
Thank you, Your Honor.
Have a good day, sir. Thank you.
You too.
Mr. Nunley, I'll get you and Mr. Q into number one.
Will probation be contacting me?
Yes, sir. I forgot to say that part. Yes, sir. They'll reach out to you to get your paperwork done and assist you on getting set up.
Okay, thank you.
Thank you.
Have a good day.
You too. Shannon, I got mesmerized for a second and forgot that part.
Am I good to go?
Yes, sir. I'm sorry, Mr. Lopez. Have a good day.
Sorry. Okay, you too. Bye-bye.
See, Miss Rep, that's,
We just got a, your car warranty is expiring. Call to the court.
are you kidding me? Mr. Lopez, were you trying to leave?
Yes, ma'am.
I'm putting you out, sir. Have a, there we go. I get those and I'm surprised. I get them on my work phone where it says spam indicated or potential spam or whatever.
It's crazy.
What's funnier is that they call my husband about a car that we haven't had from 3 cars ago.
Oh, gosh.
So I don't know what information they have. This has been a good morning. Everybody showed up.
This might be a first time.
I just saw somebody walk by in a suit. I don't know what's going on upstairs. This is 22 SU 00376A Sumter Township versus William Q.
Good morning, Your Honor. Royce Nunley appearing on behalf of the defendants. Mr. Q, please state your name.
William Coop.
Thank you. Today's the day and time set for sentencing in this matter. There was an offense date of April the 6th, 2022 in Sumter Township, at which time Mr. Q was charged with operating while intoxicated. He appeared before this court on July 14, 2022 and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, Mr. Q was referred to the probation department for interview and the development of a sentence recommendation. The court has had the opportunity to review that recommendation in its entirety along with the police report in this matter. Mr. Nunley, was that report factually accurate, sir?
Yes, Your Honor. No additions, deletions, or corrections.
Mr. Nunley, anything you'd like to say on behalf of your client before sentence is imposed?
We would just ask the court to adopt the recommendation made by the probation department.
Thank you. The court will adopt the recommendation made by Stephen Hicks. There's an indication that this is Mr. Q's first drinking and driving offense. The probation department does not recommend that he be placed on probation at this time. Mr. Q will be assessed a fine of $300, cost of $200. There are $75 crime victims fee. There's $50 mandatory state cost, $20 fund fee, $125 restitution to Sumter Township. Mr. Q will be assessed 24 hours of community service to be completed within 6 months. Mr. Q, you did not have a bond in this matter, so please contact the court's collection department to establish a payment plan in this matter. I missed something. For the community service, sir, if you do not already have a relationship with a nonprofit and you need a list of places to do your community service hours, reach out to the probation department. They will assist you in getting those and getting that list of possible places for your community service hours, okay?
Yes, Your Honor.
Anything else, Mr. Nunley?
Nothing further, Judge.
Anything else, Mr. Q?
I'm extremely embarrassed, by my actions. I'm upset. I'm embarrassed. I've ruined my life in a way that I have to now rebuild from. And I'm very regretful of my actions on that day.
I appreciate that, Mr. Q, and good luck to you, sir, okay?
Thank you, Your Honor.
Have a good day.
You as well.
Thank you.
See you guys later.
Take care, Mr. Nunley. Ms. Rapp, I believe that concludes this court's docket for the morning. Everyone appeared timely and appropriately. You're right. I don't know that that's happened before.
I know we need to write it down in the history books.
Don't say that. I will bring the files down to Virginia in just a moment. Thank you.
Thank you, Your Honor.
Mm-mm-mm.